Good afternoon, everybody. We're about to begin. Thank you for joining us. My name is Maria Premushko, and I'm a founder and attorney of MVP Law Group, a professional corporation located here in Los Angeles. First of all, I want to congratulate each and every one of you for joining this presentation because you made that first step, making sure that your family and your future are protected. The main reason why people do not plan is procrastination, and I'm fighting this uphill battle of trying to make sure that people do plan and they do arrange for their future and for their families. So during today's presentation, you will learn a lot. You will learn about what estate planning can do to enrich the lives of you and your family. Most of us tend to think that estate planning merely in terms of wills and trust. The first thing that comes to mind when someone asks you about estate planning, oh, I need a will. We all were raised on old movies and literature. And we think about who to leave our assets when we die. But those documents, even if done correctly, will not ensure that all of your life goals are secured and all of your wealth is protected. Today, you will learn that estate planning can accomplish a lot more than that. Before you begin planning for your estate, it is important to understand that you can accomplish during the process and how to select an estate planning attorney that is right for you and your particular family. You should expect that attorney to take the time to understand your hopes and dreams for your family and then counsel you on the options available under the law. It will be important for you to choose the attorney just like as your doctor whose practice is focused specifically on estate planning and whose planning process focuses on goals of your particular family, on goals of the client. You have to be certain with your attorney, just like you have to like your doctor who you're treating with. So let's go over our agenda. Today we will cover the basics of estate planning. We will discuss the purpose of estate planning. We will discuss how tax laws have changed recently and how they will change in the future. Most estate planning attorneys predict, and how that can affect your prior planning and your future planning. Also, we'll talk about if you need to, how to choose the right attorney and what estate planning is. What does it mean for you and for your particular family? The world today, our lives became unpredictable during this pandemic. One day, we're living our lives as usual. Your children were going to school, and next day, we were forced to stay home. We had to quit our jobs to take care of our children while in school. And many of us lost our loved ones, or at least got a real scare about their health and well-being. As life gradually comes back to some sort of normal, I think now it's a great time for you to make sure that you're protecting yourself and your family during these uncertain times. As a matter of fact, during the months of December and January, I had the highest spike of my clients intake because people became to realize how important it is to secure their future, to plan for their lives. Because I'm so tired of those phone calls when it is too late to plan or to sign any types of documents. So today we're going to be discussing some strategies that fly against some conventional wisdom. So you may be wondering why you should listen to me. So let me introduce myself. I'm Maria Premushka, founder of MVP Law Group here in Los Angeles, and we've assisted families since 2009. I received my bachelor degree in jurisprudence in St. Petersburg State University back in Russia, as you could probably tell from my accent. And after that, I worked at St. Petersburg District Attorney's Office before coming to the United States. Upon coming to the United States, I received my Juris Doctorate degree from the University of West Los Angeles School of Law. And before passing the bar from the first try, I interned at the City of Los Angeles, at the City Attorney's Office of Los Angeles. Throughout my legal career, I chose practices where I could help, protect, and advise clients and families to organize their lives and affairs without any interference from any government or any other agencies. In addition to that, I'm a mother, I'm a daughter, I'm a business owner, I'm a pet owner, so I know how it's important to protect your family, your assets, and have peace of mind about your family's future. I see the value in hard work. As being an immigrant and seeing my parents working hard back in Russia. And that hard work should never be wasted, trivialized, or lost to government or system, but should be guarded for your future and future of your family. After working at District Attorney's Office back in St. Petersburg and here in Los Angeles City Attorney's Office, I ultimately realized that it doesn't matter which continent or country you're in. System is the system. And as soon as you're placed in the gears of the system, it's done. It will drag you, it will eat your life and potentially to become a disaster. There has to be another option. That is why I ensure that no government agency has any say in what you want to do with your life, your family, your assets, your wealth. As you can see, I'm very passionate about it. So, what is estate plan? For many, estate planning is about making final arrangements for death. However, estate planning is about much more. In the midst of pandemic, now more than ever, it is important to plan for time when you may still be alive, but unable to care for yourself or your family. I'm so sad, as I mentioned before, receiving calls from people when it's too late to do any kind of planning or to sign any kinds of documents. And those people usually tell me, okay, they never thought that this could have happened to them, because it is just the nature of human nature, psychology. We don't want to think about death or final arrangements. But the reality is that if we do not plan timely, we still keep thinking about it. Whereas if we create our plan, we sign our documents, we can stop thinking about it because we know exactly what's going to happen in case the life strikes. So the goals of estate planning can be summarized as: I want to control what I have all my life as long as I live, as long as I'm able to, and then leave what I want, to whom I want, the way I want, and when I want, at the least possible cost of fees and taxes. Notice that taxes are the last of the goals stated above. The first three goals are personal. Leaving what you have to who you want, the way you want. And there are wise and unwise way of accomplishing these three personal goals. And in today's planning environment, you have many more planning choices right now. So what is your estate? Usually people fail to plan simply because they think that estate planning is for rich people. They think that we have to have a mansion on Mulholland Drive, luxury vehicles, large accounts, portfolios. It is not. Each and every person's estate is different. So it is all the money that you have, real estate, life insurance, home, your business, collectibles, personal heirlooms, etc. And it can differ. It could be a single mother with one bank account and hopefully life insurance, to multi-million-dollar businesses. So as a counseling-based estate planning attorney, I realized that planning for your estate should focus on your particular family, your values, and your legacy. Traditional estate planning has often just planned for your finances, your cash and investment accounts, your life insurance, your home, and all of the personal property. And those I call merely documents. If done correctly, they can avoid probate and hopefully serve the purpose that you intended. But my goal is to see the big picture of your family, to talk to you and realize what is your vision for your family. How do you want to address it? How do you see your children, grandchildren? And especially if there is any specific circumstances as a special needs child or a child that has challenges. We have to address all these issues. Also, blended families is a big concern. So we have to tailor the plan to the specific situation that you are in, that your family is right now, and foresee any future challenges and problems that may arise in the future and address it in your plan. That's why when I talk to my clients, my initial questions are not about how much you have in your account, how many properties you have, etc. We talk about your family, and sometimes uncomfortable questions arise, but I have to know your situation to properly address your needs, your values, and how you see your family in the future. So, goals of estate planning. As we mentioned, you want to give to whom you want, what you want, and on the terms and when you want. We have to make sure that you plan for your incapacity. Traditional planning usually doesn't address that, because the biggest fear that my clients have is not actually dying. It's actually becoming incapacitated mentally or physically and not being able to care for themselves. What's going to happen next? In our plans, we can address that. So you need to make sure if you become incapacitated or upon your passing, you have a plan that where your loved ones, your children are cared for. Also, you want to eliminate or minimize any probate exposure. You want to fulfill your charitable intentions. Many of my clients have charities or churches as their final, or give them some portion of their estate, or give them presents. You want to pass on values and ideas to your children and grandchildren. That's why I'm saying financial planning is not sufficient. You can actually say in the documents, plan, what is your vision for a future family? You want to maximize assets distributed to your loved ones upon your passing, and making sure they're cared for while you're incapacitated. And you want to protect these assets from creditors for generations to come, and also minimize your estate taxes. So you have to, I want each of one of you to talk to you, to have that internal conversation. As things stands now, do you have a will of trust? Any documents that you've accepted, maybe power of attorney, healthcare directive, or HIPAA forms? Do you have any documents in place in case life strikes? And we all know that life can throw the curveball at any time. If you have this trust or will been reviewed during the past 2 years? Do you hold your assets as joint tenants? Does your current plan provide for heirs, beneficiaries, and asset protection against creditors, possible divorces, ex-spouses, etc.? Are you concerned about any delays and costs of estate, if the estate can incur in case it has to go through probate? We will discuss that in the future. It is actually scary. Are all your heirs, children or heirs, 21 or older and financially responsible? Is this your first marriage, or it's a blended family? You have stepchildren, adopted children. Are you concerned with family disputes from inheritance issues? If you were to become disabled right now, are you certain that your health care and financial wishes will be honored? These are all questions that you have to ask yourself, and you have to make sure that those questions are answered in your estate plan. What are the planning options? You can also always die intestate. Intestate is not a bad word. It actually means that you die without having any plan. And it is possible. In that case, it is also a plan, because if you do not have a plan, the state has a plan for you. The judge will tell who will get what and in what terms without your participation. But it has to be your informed decisions. Sometimes if you want to look from the above and see, hey, I want to watch my children fight and see, or see how they're gonna get out of the probate, how much time they're going to spend there, etc. If it is your choice, that's totally fine, but it has to be informed decision and not done by mistake. You can spend it all. I'm sure if you've seen all those cars with license plate, hey, luxury cars, saying I'm spending my child's inheritance, but beware. It is also an option, but unfortunately we don't know how much time we have to live, and we have to make sure we have enough money left for your retirement or for your possible long-term care needs. You can execute a will. You can hold titles in joint tenancy, and finally, and the best option, you can have a living trust. We call it MVP, a wealth trust. So let's start with a will. As we know, as we mentioned before, many of us think of estate planning as having a will. Please remember, if there is a will, there is a probate. There are many instances where will-based plan is the best option. And one example could be an estate where litigation is expected. A probate can be the best way and process to oversee its litigation and can provide the structure needed to settle dispute in the family. Also, if there's what I mentioned before, a single mom with one child and one bank account, there is no need for a trust. Will package will be sufficient. So it is not my job to upsell you or shove you in with the living trust and make you sign documents. No, we're going to discuss each and every family situation and decide what type of planning and what type of protection is needed for you specifically. What are the risks of will-based plans? Some risks associated with the will-based planning include, traditional will plan provides little guidance for disability planning. Also, you'll have to execute a financial or legal power of attorney that must be drafted, but most financial powers of attorney do not include instructions for care of individuals, as well as authority to provide for the needs of anyone other than the person executing the power of attorney. So if you have a will and if you become disabled, there is nowhere to provide for your loved ones, for your children, for your spouse. Whereas in the trust, we can address those issues. Another risk of will is that many assets are outside of the reach of the scope of a will and often will be unplanned for. Wills do not control most property, including retirement accounts, annuities, insurance policies. And lastly, because a will is only used to transfer property at death, if any custom planning is included for beneficiaries, you will still have to create additional trust for your kids or other beneficiaries. So let's see how estate works with a will. As we discussed, your estate is everything you own. Now, for instance, you have a will prepared. This document allows you to select the individual, usually it's a child or any other person, who you would like to wind up your affairs, also known as personal representative or executor. That person will receive your money and property and will have to manage it and transfer it to your beneficiary, person who will get certain portion of the whole estate. They will have to appoint a guardian for your minor children. However, even though you have taken these steps to put your wishes in the official document called the will, your accounts and property will still end up in probate when you die. The personal representative will still need to have to pay any taxes owed and will likely face at least several $1,000s in probate fees, including attorney fees, appraisal costs, and yes, that representative will also have to be reimbursed for the services. It will gives you the added benefit of allowing you to choose who is the individual who will receive your inheritance, but the case will still have to be probated. So why are we so scared about probate? What is it? Perhaps one of the most attractive and popular reasons why many people choose to use a revocable living trust is that any accounts of property that are properly transferred into the trust, and that process is called funding, will avoid going through the probate process. This could save your loved ones lots of time and money and keep prying eyes away from your family affairs because it's going to be private. For example, in Los Angeles County, it takes about 2 years to process the estate through the probate court. And 25 to 35% of the total estate will be lost to all kinds of fees and expenses. Let's take into account just attorney's fees. Let's take as an example an estate worth of $1 million. And what is $1 million here in Los Angeles County? It is probably one house, a couple of accounts, life insurance policy, 401k plan will take standard family. And if I represent children or heirs of the estate, let's say we have family passed away and children want to probate the estate, I personally will make $25,000 at least out of 1 million estate. I do not mind that. I make much more money while probating the estate. However, I do not like doing that. Well, I like doing that we do the service for clients, but I would rather act proactively, meet with you, create the plan for the future, and avoid probate at all costs. And it costs, believe me, much less than $25,000. So additional probate issues is living probate. Probate court may also be involved in your life if you fail to properly plan for a period of mental or physical incapacity. Probate court is authorized to name a guardian, a conservator on your behalf. That person would be authorized to manage your finances and to make healthcare decisions for you. And please keep in mind, that's called living probate. Let's say you become incapacitated and you don't have any documents executed, then your loved one or any other person can step in and petition the court to become your conservator. And that may be the person that you do not like at all. Let's say you have 3 children, one child is estranged, 2 other children are good, but they're so busy with their lives, they didn't bother to petition the court. And you have a estranged child with financial issues, history of bankruptcy or addiction, take over your estate. I'm sure that is not what you would have intended. Or if you have a business and court appoints somebody who has no idea how to run the business to manage your affairs. So, and also it is so unnecessary. It is so easy to liquidate this issue. And this process also of living probate is humiliating. You will be publicly stripped of your rights as an individual, and you will be, person will have to be willed into court usually and pronounced incapacitated. As a side note, I wanted to mention, if you watched I Care a Lot on Netflix, that is, of course, exaggerated version of somebody else becoming your conservator instead of your loved one or person that you wanted to be your power of attorney or your representative. It is scary because court is not obligated to appoint your loved one, your spouse, or your child, somebody who can step in and ask the court to be a guardian, a conservator, and court may approve it. Joint tenancy. Another way to avoid probate is having title, having your assets titled as a joint tenancy. So we mentioned earlier in the presentation that the will does not control every asset that person owns. And one example of this asset owned as joint tenants with right of survivorship. With an asset owned in joint tenants with right of survivorship, the last person alive owns all the property, not the partial ownership, but the whole thing. If it is, however, included in the value, it is, however, included in the value of your total estate for the purposes of probate and paying estate taxes. So if you get anything out of this presentation today, I would strongly encourage you to have this: do not own any property as a joint tenant unless it's intentionally done and is a part of your plan. Also, because the will doesn't control the asset, it is not subject to the probate court, and the last person who owns the asset cannot legally be compelled to give back the portion of the asset they just received as a joint tenant, and that has consequences. So, for purposes of this example, we'll assume that you have 3 children. Let's see how your estate works with joint tenancy. If your bank account is owned jointly with one of your children, one of 3, and then the child will receive 100% of it upon your death, a joint owner is automatically entitled to 100% of the property on the death of the other joint tenant. As you can see in the picture, the other 2 children are completely cut out, and only 3rd child receives your bank account. Option number 2. Let's say you decided to avoid probate by naming your child as a joint tenant on your real estate. If your home has a transfer on deed death or joint tenancy, then those people named on the deed will receive it. In case your 1st child will receive the home, your middle and 3rd child are totally out of the picture. So so you will have unintended beneficiaries, or it will result in an equal distribution of your estate. And most clients, most people I talk to, unless there are any specific circumstances, they want all their children receive inheritance in equal shares. So it is not the best idea for avoiding probate. Also, for your accounts such as IRA, 401k, or other investment accounts with beneficiary designations, if you name just one child as a beneficiary, that particular child will receive the 100% of that portion of your estate, unless any special documents are executed. And from my experience, I always see that usually people think about their oldest child or the most responsible child as the joint tenant or the power of attorney or the beneficiary designations. And often happens that that particular child receives everything. And it wasn't that your intention. It wasn't our client's intention. So, joint tenancy, let's repeat it. This type of ownership, as I said, often produce unintended heirs or disproportionate share of an estate going to one individual. For example, you and your wife have own a house in joint tenancy. So if you pass away, let's kill the husband first. Husband passes away, wife gets everything, 100% of that house. Let's say she remarries and has new kids, or new kids come from blended marriage. As a result, the new family, the new husband, and new kids can receive 100% of that house. and original family, original children will end up with nothing. That's just one example how it can play around. It is important to know that this approach doesn't avoid probate completely, because the assets still will need to be probated at the death of the second owner unless they've executed their set of documents, leaving the original family out of the picture. Lastly, there can be unintended income tax consequences with joint tenants with right of survivorship. Because the asset doesn't pass through the estate, the cost basis of the asset doesn't get the benefit of stepping up to the value of the asset at the time of the person's death. This is a tax benefit that's only available if assets pass through the probate or trust administration process. And then when the asset gets sold, there may be additional capital gains taxes owed. So here we are discussing some maybe advanced issues, but you have to at least become familiar with what estate planning is, because you see here we address very serious issues. It's not just drafting a will, it's planning for your future and future of your family. So you can see why in our practice we recommend a comprehensive estate plan instead of just will or as I called it, patch it probate avoidance techniques. We need to talk to you and to discuss which plan should be specifically designed for your family to address your possible needs and your possible heirs. Okay. We touched up on beneficiary designations, and these assets all have similar manner in passing to your beneficiaries at the time of your death. And pay on death, transfer on death clauses on your accounts, or 401ks, life insurances. Hopefully you have beneficiaries designated there. So I would encourage you to please go back to all of your accounts, life insurance, 401k, and make sure that you have at least some beneficiaries named. Preferably, usually we have trust as a beneficiary on a second beneficiary in case there are minor children. So there are a lot of things to consider. What we pay, we commonly call these check in the box transfers. And these assets direct the asset to the designated beneficiary at your death, and they do not pass through probate process and are not subject to the terms of the will. So again, possible that it is possible that it will not protect your spouse. That if you're okay, let's start from the beginning. So you have to use great care while designating the beneficiaries for these accounts, because they have to match your overall estate plan. Because let's say it is your decision to make sure you have a business, you have large accounts, and your main idea is to create asset protection plan. And at the same time, you name a single person or single child as the beneficiary of one of these accounts, that can totally diminish the value of the whole planning. That's why we'll look at your complete situation and analyze all of your accounts and decide which account and how we should appoint the beneficiaries. If it's a spouse, if it's a child, if it's children equally, or we name a trust as a beneficiary. And again, we spoke about unintended beneficiaries. So scary, because let's say blended family, and husband brought in 401k from when he started his employment at 20 years old. And when his company offered 401k plan, he entered his prior spouse name as a beneficiary and didn't take any thought to it, didn't think about it, and didn't update the beneficiary when became married again through the second marriage. So what happens? He passes away. Neither his existing spouse has right to inherit that, nor children. His prior spouse will receive the money, or if she's not available, if she's not there, her heirs will receive the money. These are real risks of real life, and I see it every day. People just are either ignorant or forget, and that has extreme consequences. So we're coming back to our MVP plan. You have to choose the trust, and that is why. We've talked about the potential risk associated with will-based estate planning, joint tenancy, just appointing beneficiaries. And I would like us to turn our attention to living trust-based planning, and when this type of planning is appropriate. You should choose this. You should choose a trust when you value the following. You want the estate plan that will take care of you during your life and not just at your death. You want to keep control over the plan during your lifetime. You want to plan for mental or physical disability, including how you want to be taken care of and who you want to make those decisions on your behalf. Extremely important. Also, you should choose the trust when you want to provide planning for your descendants, considering whether the inheritance should be given outright, in stages at certain ages, or in a lifetime trust providing the beneficiary protection from himself, herself, creditors, divorce, etc. Lifetime beneficiary controlled trust is not an asset that is owned by your child, grandchild, or any other beneficiary. It is another level of protection against creditors of your beneficiary, of your child and grandchild. Protection can even include protection from a divorcing spouse. So let's say you have your beautiful daughter. She's smart, hardworking. She's an adult. She's a CPA, let's say, but that boyfriend of hers, you don't like at all her choices of boys, right? And you want to protect her. If like simple trusts or poorly drafted trusts usually give inheritance to your children outright. Let's say she marries that boy that you've never liked. She's married at the time when she receives inheritance. And usually, no matter how smart our kids are, no matter how educated they are, it is just a psychology to put the inheritance, that check that they receive, into the joint account of the family, or even if husband had access to her account. And that means automatic gift to the community. That means that guy you've never liked from the beginning, who laid on a couch all the time while your girl was working, can divorce her the next day and receive half of the inheritance of what you've worked so hard all your life. I'm sure that is not an intention. And whenever I talk to my clients, usually, sometimes they come to me and say, hey, we need a simple trust. But when we discuss their situation and we dig into family dynamic, we can unload this possible issues, possible liabilities, possible scenarios that we can address right now for the future. And usually my clients choose to have all these kinds of protections. It's not always necessary, but you have to know that it is an option. While the beneficiary doesn't own assets, your spouse, child, or grandchild may serve as trustee of the trust, providing them with a level of control over the inheritance. In my experience as an estate planning attorney, planning for distributions of descendants is one of the most important assets of estate plan. How will they receive? For example, I had a client who came to me and she said, okay, I want to leave everything to this charity, actually the church. And of course, I have to ask questions. And she said, yes, I have a son, but there is no way I'm going to give him anything. Again, I have to ask an uncomfortable question, why? And it happened to be that he's an drug addict. And she said, I know if he receives this inheritance, that means he will either die of overdose or give it to his friends or spread it. So she didn't want it. And when I advised her, okay, there is a way to plan for your son. We can create an incentive trust for him. Whereas we don't give him, we tell him, hey, here's the money for you. It is possible for you to get it, but you have to be clear of drugs for a certain period of time. You have to have a job, or you have to start school or continue school. And that gives a mother and this guy at least perspective, at least hope that there could be a change, that he can change and he can get the money and live a better life. So of course she was crying and thankful, and that's what we did for her and her son. Hopefully they'll be fine. So with a trust, you can design a, as we were mentioning, you can design a custom plan to distribute your estate at the time of your death, providing comfort and asset protection for the surviving spouse, caring for minor children in the event they need to be raised by guardians, providing an inheritance with protection to adult children and grandchildren. If you have an existing will or trust, or considering your first estate plan, the best way to retain control of your asset and provide for your loved ones is by designing a customized plan for your beneficiaries. This is possible when using a living trust as your estate planning document. So when planning for a trust, you also have the opportunity to plan for your personal values. When working with clients, I realized that they're often interested in honoring their church, synagogue, charities, or any other charity, or animal society, or veterans. The options are unlimited. In addition, special care needs to be given to planning for pets. We can counsel on the best way to plan for the care of pets should your pet survive you. And we know in Los Angeles area, there are many couples that own pets and have no children, and pets are their life, and we care for them. We just recently drafted a plan for a horse owner. So the trust base gives you control and allows you to plan for these important values in your estate plan. And especially, I haven't addressed it yet, special needs children. We have to make sure that your special needs child is protected, because at the time they become an adult, they can qualify for government assistance. And if plan is not created the right way, they may receive an inheritance outright in their bank account in their name, and they will be stripped of that government assistance. We have to make sure that special needs children are protected for the future, and that we create and design the plan for them specifically so they will not lose government benefits and have this extra protection for their any extra expenses for way of life, etc. Very important. Also, there are laws that govern the transfer of firearms. So it is highly regulated, and gun trusts can be created at all as well to make sure guns are transferred properly. When planning with revocable trust, you can save money by avoiding probate costs. As I mentioned before, fees and costs are insane. This is because revocable living trust replaces your will as the estate planning document used to distribute your assets at the time of your death. Basically, you become a creator of the trust, grantor or trustor. You become a trustee, a manager of the trust, and it's basically an agreement between you as Jane Doe and Jane Doe as trustee on how to manage the trust. And you appoint successor trustees who will manage the trust and administer the trust based on all of your decisions. You will save the money on all the fees and fees and costs. Probate court is not needed. It is private. Nobody will know what's going on with your family. It is none of your neighbor's business how many children you have, how many marriages you had, who you decided to disinherit, how much money do you have. So if you create a living trust, it all stays within the family. By now, you're familiar with this diagram of our accounts and property. So you can see them on slide already. So during your life, you fund everything into your trust. I help you with, I hold my client's hand, so I'll help you with all the funding process. This is done by changing the ownership of the accounts and property to the trust or by naming the trust as a beneficiary. While you're alive and well, you continue to use money and property in your revocable living trust as you always have. You can sell, you can buy, you can refinance, you can close accounts, you can always open new accounts. Just keep in mind, you always have to title or retitle property back into the name of the trust. You're in complete control of the accounts and property in your revocable trust. However, there are certain types of irrevocable trusts that are designed for specific needs, such as medical planning or asset protection planning. That is beyond today's presentation, but I will be happy to discuss it with you. If your wealth is more than 5 million, let's say, we can take more steps into detailed planning and discuss what asset protection options are available. So those trusts work a little differently, and we'll discuss them. After you die, your trust provides the instructions for distribution to your beneficiaries. Unlike a will, there are no probate fees, no probate court involved. There are some trust administration costs associated with the trust, but there are no comparison with probate costs. Usually, trusts are designed that way that it gives specific instructions of what has to be done and in what consequences. So usually, just educated person can do that. Often, my clients, or the beneficiaries of my clients, ask for initial consultation where I give a brief overview of what has to be done upon someone's passing, and they take care of themselves. If they don't want to, or they're busy, they can hire an attorney to administer the trust, but it's no way compared to the costs of the probate. And of course, taxes. A trust can significantly reduce and sometimes even eliminate estate and income taxes. The revocable trust or other planning options that we discussed, it is so interesting. You can take money from your left pocket, make some arrangements legally, and put it back in your right pocket, and suddenly these assets become non-taxable. But this is, again, it is beyond our presentation, but we can discuss it for your particular family if need arises. Comprehensive estate planning is not complete without proving solution for asset protection and income tax planning. We can do all of that. Basic protection. When we talk about with my clients, as I told you, we're not just talking about what's in your bank account and how much you owe. We'll look at the whole picture and how to protect you for the future. Basic protection includes long-term care, liability protection, medical protection. I work in collaboration with life insurance specialists, financial planners. So if I see the need, I always refer my clients to those professionals, and we work in collaboration. We have a team of specialists that can help you to make sure so you sleep tight at night that your future is protected, that you are not afraid of possible creditors, etc. There's business protection. We discuss what types of business you have. We always encourage people, of course, form corporations or LLC. We transfer the title into the name of the trust. We make sure that bylaws and operational agreements are drafted properly, and that trust is incorporated in that. And there are additional possible planning for asset protection, such as life insurance, irrevocable life insurance trust, bypass trusts, etc. But again, we're talking about if your estate is more than 5 million. Now, I would recommend doing that, but it's again very unique conversation between me and my clients. Please consider that although right now estate planning exemptions is 5.5 million and 11 million for a couple, it sunsets on December of 2025. And many of you may know that there's a new law that was proposed by Bernie Sanders and another representative, that to reduce that estate planning tax to 3.5 million. And what is 3.5 million here in California? That's probably a house and a half south of Ventura Boulevard, and several accounts with your financial planner, and that is it. Anything extra that your heirs, your beneficiaries, your children will have to pay property tax, which is almost half. So if you're not planning for asset protection for the future, that means you're conveniently holding almost half of your estate for the IRS. They will thank you for that, but it is not our intention, and we make sure that we address these issues. Yes, so we discussed that. So it was a bit heavy on you, I understand. We discussed a lot of things, a lot of structure, a lot of information, what estate is, why we should plan for our estate, what options are available. It is up to you what you're going to choose, either patch it, like a Band-Aid type of estate, just based on will, or complete comprehensive MVP package. And of course, I encourage you to do that. However, if your family does not need that, that is totally fine. So you have a choice. You've learned a lot today, and the question is, what will you do with it? As the English philosopher Herbert Spencer said, the great aim of education is not knowledge, but action. If you click away from this training, telling yourself that you will get around the estate planning someday, remember procrastination. If so, chances are you will be among those who make the first mistake, procrastinating until it's too late and having no plan at all. Again, remember, it is also a plan of having no plan at all. But if now, having all this information, you fail to plan for the future, it's on you. You made your informed decision about non-planning. Or you will decide that now is your time. You will step up now for yourself and for your family, become a beacon for your family and for those who depend on you, and for everyone you love. Today is the best chance to finally get this done. If that's you, if you're committed of doing your best and making plans you can trust, then here's how I can help. I understand that estate planning has historically been viewed as necessary evil. However, comprehensive counseling-based estate planning solves that problem. Estate planning is now an opportunity that you don't want to miss. What are the usual excuses my clients have? Estate planning is a luxury and not a necessity. I don't want to think about it. It costs too much. I don't have enough property. I don't like attorneys. You do like me, I hope. I'm going to do it myself. Well, all those may be valid for you, but I do encourage you to talk either to me or any other attorney that you feel comfortable talking with, and discuss the options and the issues that we discussed, that we spoke before. Okay, finding the right attorney. It is important. You have to feel comfortable with the attorney, just like as your doctor. So your attorney has to focus on estate planning, has to collaboratively work with other professionals. We do estate planning attorney, CPA, insurance broker or agent, and financial advisor. Very important to have collaborative view on your particular situation, what can be done with your particular estate. And what is the process of keeping estate, the plan. I hold my clients' hands from the beginning to the end. I help with funding. I don't trust my clients. I know you have your own life, so I help you with transferring accounts to the name of the trust, filing the new deed with the county office. So we hold your hand and make sure that your plan is complete. And our comprehensive plan includes, let me show you a brief. So this is the plan. This one particular is done for a married couple. So it's more than 300 pages, and believe me, it is not the quantity, it is quality of the product. I constantly review other plans created either online or by some CPAs or even other attorneys. And one trust I had, it was 17 pages long, including table of contents. So we have fully funded trusts for our will, guardianship provisions for minor children, healthcare power of attorney to take care of, or to make healthcare decisions when you are incapacitated, durable power of attorney, statutory power of attorney, living will, HIPAA releases, personal property memorandum, memorial instructions, trust ID cards, everything is in here. So you can have this document on your shelf, and the next of kin, should something happen to you, can just grab this document and know where to go, what to do, and keep family. When something happens, life happens, you want your family being a family together, mourning or holding hands, and knowing what to do. Also, my plan includes that initial consultation when life happens, either disability or death of a family member. My clients come over, we talk about it, we cry, we drink, whatever is necessary for my clients. We make sure that I give them instructions on what to do next. Bare bones trust. I touch based on that. So that being 17 pages trust. Even if done correctly, they do not address the whole thing. They address only financials and passing the probate. In some instances, it does work. So I will not upsell you for asset protection trust when you need a real simple trust, when there's, let's say, there is one parent, one adult child, no issues. So bare bones, as we call it, trust may be sufficient. But be careful when creating those types of documents online. There are a lot of state laws that have to be followed, and it has to be properly funded, and etc. So because right now I have 2 probate cases when people had the trust, they paid $1,500 for the trust, they're certain they've executed it, but it means nothing. It hasn't been funded. It didn't have proper documents in it, and we still have to go through probate process. We're right now 1 year in the probate process when they had living trust and thought they had a good one. Very, very sorry it happened, and some paralegal prepared it, and there's no even recourse. If it was an attorney, we could do something, but now, no. Okay, so our estate planning process. When you talk to us, we first have initial meeting. We establish relationship. You decide, we both decide if we can work with each other, because I had to fire my clients sometimes because I see there is no click and they're not participating or they're not following up the instructions. Where we discuss your particular situation, your objectives, learn about your family, dynamic of your family, your assets. If necessary, we engage other professionals such as insurance agents or state or wealth advisors, and you fill out the forms. You provide us with the asset information. We have design meeting, and we go through each particular steps, and we discuss which way of design is better for you. You and your spouse, if there is a spouse or significant other, will discuss together how you want your estate to be planned, how you want your children to receive inheritance, on what terms, on what ages. If you have special needs child, you have pets, you name it. Then we have our final signing meeting, where you come over to my house, to my office, and or I come over to your house. I do make house calls for older people and people with limited mobility. So I'm one of the few attorneys in the area who does house calls. And then we have final signing, and we deliver the plan to you, and we go through the funding process. And then I manage you through life. I'm not saying you goodbye. I will always give you a call, send you a birthday card, call you in a year and a half, or send a letter saying, asking how are you. If anything changed in your life, if you have new property, new child, divorced, whatever your life may be, I will be on top of it, and we make sure that your trust addresses all those wishes. So here's what I have for you. I've set aside time in my calendar in a few days, in next few days, to speak with you personally about your situation and possible solution. Whatever is your biggest challenges, I most likely have seen them, and we can help you to overcome them. And the cost of this call is absolutely free. I will personally call you. On this call, we will help you understand the biggest concerns that you have right now, the important people in your life, your property, your plans, and your hopes, how to protect them. If I think that I can help you solve those problems, I'll tell you so, and outline the exact next steps that you should take. Probably you're wondering how much that plan may cost. But without having that, all the information about your particular situation and your family dynamic, I cannot tell you so, because my clients range from anywhere from just preparing power of attorney, healthcare directive, and HIPAA form, all the way to multi-million-dollar clients that need comprehensive asset protection plans. So without talking to you, I cannot give you the exact amounts. But before you hiring me, you will know exactly how you're gonna and how much you're gonna pay me for the plan, because that's how I want to be treated. I want to be transparent. So I do not charge extra for phone calls, emails, conversations, office visits, etc. Everything, you will know the flat fee that you're gonna pay. It gives you peace of mind. Again, peace of mind is my motto. I want my clients to have peace of mind. But this call is not for everyone. It's only for people who really recognize that they have an estate planning problem, and as things stands now, their children and family are not protected, and most importantly, are committed on solving it. And you're done procrastinating, and they're ready to take action and protect your family. So why am I doing this? Because I stand against the machine that doesn't care about people, but they just want to move cases, and they're not successful in doing that promptly and fast enough. I want to help you guard your affairs without any interference from government and other entities or agencies. I believe that people deserve dignity and have their life's legacy protected from the system. I believe in education, because very few people know about all the things that we discussed today. and about the possibilities and types of protections that are available. Only rich people can do that, and even not them. Have you heard of Larry King passing recently? And he didn't have trust. He had only a will scrambled on piece of paper. Now we hear on tabloids what's going on with this probate case, how many children, what it was his estate worth, ex-spouses contesting it, etc. It is a mess. So anytime you hear in tabloids or TMZ talking about celebrity passing and the inheritance battle, that means they did not have a plan. Anytime somebody passes and you don't hear about it, that means they had a good plan and nobody knows about it. It's all done within a family and with peace of mind, and I'm sure that was their intention. So as you can see, I'm passionate about providing people with all the tools possible to ensure that they make decisions about their lives and not somebody else. Don't let that court clerk put a mug on your file. That's just not right. So it is important to know that each of one of us has a will, whether you have signed one or not. If you have not signed one yourself, the state of California has drafted one for you by default by enacting statutes that say who will inherit from you and on what terms. That means dying intestate, as we said before. And you also lose control over who manages your estate, who manages yourself and your money and your finances while you're incapacitated. And you also lose control over naming a guardian for your children if you have minor children. Oh, it is so scary, because court can appoint somebody that you wouldn't trust your child with. It could be a family member, but you know that aunt or that cousin is not the best fit for your child. Whereas in a comprehensive plan, you can address all those issues and actually outline how your child should be raised, what church they should go to, who should be the doctor, what kind of movies they have to watch. At least you know that from your point of view, you've done everything possible to protect your children and your loved ones for the future. So again, coming back to that movie, I Care a Lot. Are you a lion or a lamb for your family? And I don't want it to be disrespected. It is in a bigger perspective. Lion, somebody who is a beacon, who cares for the family, who wants to make sure that peace of mind persists, assets are protected, families generate. If you hire net worth, that generations to come are protected. They don't have to pay extra estate taxes or any other taxes. Or if you have a minor estate, if you and your child, you have your children protected. So you can be a lion for your family, no matter how big or small your estate is. So here we can direct, here's my information. There's a phone number, there's an email address, and there's a website where you can book your consultation by yourself. On the right-hand upper corner of the website, book a call. So I'll give you time to write down the information, and we will try to contact you as well. So you will hear from my assistants. So my practice is a mixture of emotions. When we create a plan for the family and they sign the documents, everyone is happy, and you can almost physically see the weight of thoughts or uncertainties is lifted from their shoulders. Facial expressions change. They achieve peace of mind. But as we know, life can happen at any time and unexpectedly, and strike at any time. When I receive a call about my client's incapacity, disability, or dying, of course, there is sadness and mourning. However, at the same time, there is certainty, there is peace, and confidence about the future. Understanding that during this difficult time, family isn't torn apart. Everybody knows exactly what has to be done and what will happen in the future. Legacy is preserved, families united, and they only have to concentrate on what is really important, their families. Well, I love my job.